Hey guys, chapter four. We're on chapter four already. It seems like this semester's flying by. This chapter is titled Types of Evidence. I love this. This is kind of in my wheelhouse. Although most of you know, I spent 15 years in law enforcement. I've been a city police officer, county police officer, and a state. Worked for the Missouri State Highway Patrol. And I got a law degree after that. So I really enjoyed the legal stuff and the types of evidence and how it's used in an adjudication process. So this, although I enjoy all of it, this is really one of the chapters that I really enjoy. So if you have any questions, don't hesitate to call or message me. We can work through this. Some of it gets complicated. Sometimes you think about the types of evidence, and that sounds simple, but it's actually a complicated chapter. So reach out if you have any questions. I want you to understand this to move on to the next chapter. And again, it's extremely interesting. And as we discuss evidence and how it's used during the adjudication process, it's particularly interesting to understand not only how it can be used, but what's not admissible. So some things you think is admissible and it should be obvious, or morally it should be. There's a step that someone missed and it's not, you can't use it in court. And that's how defendants get out of things. So if you're wanting to move on, or you are a police officer, you want to move on to be a police officer, this is I want you to know this stuff, because you can collect evidence in a wrong way or present it in a wrong way, and that allows a guilty defendant to get out. I want you to know the material evidence and how it's deemed admissible in court, just like we said. Then I want you to be able to define circumstantial evidence and understand how it's different than direct evidence. Know what testimonial evidence is. Know what real evidence is. Understand the presumptions at a trial. Uh, so, and I think when you presume, you know what presume means, but I want you to know what presumptions are at a trial. I've also included the timeline from a trial. Some of you are probably too young to remember the Casey Anthony case. She was charged with murdering her 2-year-old daughter in 2008. And the evidence seemed to suggest that the prosecutor had an amazing case to convict. She gets out of it. So that's a particularly interesting case to know how evidence can be presented, and maybe how it's presented in the wrong way. And someone that's guilty, she's guilty. And I probably shouldn't say that, but I think we would all look at the evidence and know that Casey Anthony is guilty of murder. But now she's walking free simply because the evidence wasn't presented right, and the jury believed that she wasn't. And sometimes, even though we're looking at everything, that jury didn't see all the information that you're seeing because it wasn't presented at trial. So in the classroom discussion, you're asked, does our courts allow too much opportunity for a defendant to be acquitted than it should? I want you to talk about that. So make sure that you think about that. Don't just answer it. Think about it. Does our courts allow too much opportunity for a defendant to be acquitted than it should? Personally, I don't think it does. Um, when you're uh, and I think we know that when you talk about the standard or the proof that's needed to convict someone in criminal court, it's beyond a reasonable doubt. And that's a high standard, because I think we'd rather let people go free than to convict people that aren't guilty. So occasionally someone's going to go free because that's how our system is set up. And I think that's right. I think you just have to make sure that your job is done right, and the constitutional protections are set in place and they're followed. Um, I also I want to discuss circumstantial evidence a little right now. What is, because we hear circumstantial, all that evidence is circumstantial. We hear that all the time. But what is circumstantial evidence? And it's simply evidence that infers the crime could have happened. It doesn't prove the crime happened, but it infers, and that's the word I want you to remember. And it infers the crime could have happened. One piece of circumstantial evidence could be something that could not prove beyond a reasonable doubt that a crime had been committed. But what about 10 pieces of circumstantial evidence? I think so. I think so. So you can be convicted of a crime based solely on circumstantial evidence. As long as that case is presented that it is proved beyond a reasonable doubt the defendant committed the crime charged with. I don't care if it's all circumstantial evidence, they can be. And I think, and I think that's probably right. And you'll hear attorneys say all the time, and I just said this, that evidence is circumstantial. The next piece of evidence is circumstantial. But if you've got 10 to 15 pieces of circumstantial evidence, maybe even 3 or 4 pieces of circumstantial evidence, that's probably going to be beyond a reasonable doubt, just depending on what they are, that the crime was committed by the defendant. So an example of circumstantial evidence would be that a suspect is seen running away from a murder scene. That alone does not prove that the suspect committed the crime. But what about if you provided more information? That a gun was in his or her hand and the suspect was talking about killing the victim 3 days before. Now, is that enough? I'm not sure. I'm still not sure that's enough, but boy, we're getting close, aren't we? If someone was seen running away from a crime where a murder happened, they had a gun in their hand, and they were talking 3 days before about killing the victim, man, we're getting close to being able to have enough to convict. So if they want to get out of that one, they better have a good attorney. And that's all circumstantial evidence. Understand relevant evidence. And relevant evidence, it's simply any evidence that tends to prove or disprove a disputed fact in a case. So I think we know what relevant means. So if it's relevant to a case and it's a piece of evidence that's relevant to prove or disprove a fact or a disputed fact in the case, it's going to be relevant. Know what at issue refers to. It's simply a term used to describe whether or not something is relevant or at issue in the case. So if something is not an element necessary to prove if a crime did or did not occur, it's not an issue. So there's no time to be wasted on it. So there's no reason to discuss it. And you'll hear that a lot during court. You'll hear relevance. You'll hear the attorney say, relevance, judge. And then the attorney presenting the case will say, give me a little time, or here's it's relevant because of this. And if you can't explain that, or you may be allowed a little bit of time to move on to show relevance after 2 or 3 more questions. But if it's not relevant, you can't waste time on it. So when a defendant enters a plea of not guilty, all facts needed to establish the crime are placed at issue, as the prosecution must prove their case at that point. So when a defendant enters a plea of not guilty, if they enter a plea of guilty, all that stuff kind of goes away. Then you're just talking about the judge, and there's really not a trial because they pleaded guilty. But when they enter a plea of not guilty, that's when it starts, right then. Also want to touch on one point regarding relevant evidence. You'd think that all relevant evidence would be admissible in court. And I touched on this a little bit earlier, but it's not. Even if it's relevant and considered at issue, if the defense or the prosecution can establish a defense or reason to suppress the evidence, it can be thrown out. So remember that. You're not, just like in the Casey Anthony case, we knew all the evidence while court was going on, but we knew she was guilty, but the jury didn't get all of that because a lot of it was suppressed and thrown out. Okay, again, it's an interesting chapter. Read over the chapter, the PowerPoint, and all the other information, and let me know if you have any questions. Thanks so much. Have a great week.